Okay, we're in the wonderful world of bankruptcy. This is an exciting area for a number of reasons. First of all, a lot of people go through bankruptcy. Founding fathers have gone through it. Famous people have gone through it. So it's something you should be aware of how it works. And the objectives, the public policy is to give you a clean slate. If an unfortunate debtor has made mistakes, the idea is to eventually give you to discharge most of those debts, not all of them. Understand there are two basic types of bankruptcy: liquidation. This is applies to individuals and to businesses, and this is pursuant to Chapter 7 of the bankruptcy code. The others are called reorganization. This is Chapter 11, which is for businesses, and Chapter 13 for wage earners, for individuals. Important to understand when you file for bankruptcy, it's a federal issue. You go to federal court for that. You have to identify all your creditors. People can make claims, and then eventually you're discharged. Sounds painful. Takes about 3 months. Really, it's not that painful. You have maybe one meeting with creditors if you're a Chapter 7. No one actually wants to deal with you because you're viewed as having no assets. To qualify for a 7, the trustee, you'll see here the role of the trustee, evaluates your assets, and if you've got nothing for creditors to get their hands on, you do a Chapter 7, and you get to keep a lot of stuff. It's amazing, and you'll see how that in your book. The trustee will gather your estate, your property, and determine, what is subject to creditors and things like that. Big protection with bankruptcy is automatic stay. That prevents most creditors, from taking any further action to recover recover debt. But they can petition for relief of stay. This is typically what a mortgagee or a lender on a home will do, and then the lenders are called mortgagees. Uh, that's why it's important, as we discussed in the prior week, to know how a creditor should protect themselves through the process of secured transactions. If you're a secured interest, you have priority in you have some priority in bankruptcy. It doesn't mean you're going to get paid. Unsecured creditors like credit card companies get nothing. So that's if you're underwater in credit card debt, it's probably prudent to talk to a bankruptcy attorney to figure out if it's time for you to pull the trigger and try to get out of that. There's a lot of property that's exempt that you can keep. Depends on state and federal law. It gets fairly complicated, so it's prudent to talk to a professional. There are a number of things that are not dischargeable in bankruptcy. Of primary concern to students is student loans. There's ways to address student loan debt, workouts. Depends on if you're going to work for a nonprofit, things like that. And then there's a thing called a hardship discharge, which is somewhat of an oxymoron because you think you're already in hardship. But there's students that apply for a hardship discharge as part of a bankruptcy. About 1/3 of them get their student loan discharged.